said a visitor. I thought Mom.
I've been busy.
It's good.
But that wouldn't apply to her in this situation. I see. She's not visiting as an attorney. She's visiting as a good wife. Get it? Hey guys, it's Jeremy with Civitas Law Group. I'm excited today. We're starting a new show. A lot of you have been asking for The Good Wife, so we're starting with The Good Wife, Season 1, Episode 1.
Hey, you all right?
Starting off with a misdemeanor assault. I mean, it sounds like he deserves it, don't get me wrong, but misdemeanor assault nonetheless. Luckily for her, nobody's around to see it. Everybody else got away. Didn't see some cameras in the tunnel, though. That might be bad for her. Doubt that's going to be part of the story, though.
You take the witness prep on highway redistribution. Don, you take the Brighton criminal, and Alicia will take the pro bono. Everyone else, your task is to show Schifrin Marks our A game, okay? Let's do this.
So I don't know. They said Cook County, so I'm assuming we're talking about Cook County, Illinois. So I'm assuming this is in Illinois. I do not know their rules on pro bono, but there are a lot of states in the Midwest that actually have required pro bono. And somehow, and I don't know their ethical rule that allows them to do this, but somehow they can assign somebody in the firm to essentially do it for them, is the way that I understand it. Looks like that's what they're trying to go for here. If I don't know the rule and you do know what it is, please feel free to tell me, because I have always been interested in it. In my two states that I practice in, Arizona and New Mexico, we do not actually have a required pro bono element of our license renewal. We don't have to do that, but a lot of them do. So, looks like that's what they're up to here.
Okay, our investigator can get you up to speed for the bail hearing at 3. Cormac, I'm ready.
The hearing's today?
Well, we could delay, but that would leave Jennifer incarcerated for another month. Don't worry, you'll be fine. The ASA is not going to argue against a recognizance release. Go. Meeting's at 10:30.
Okay, so freaking out over a bail hearing, probably not, even for somebody that hasn't been practicing law for a very long time. Bail hearing is pretty straightforward. The prosecutor is going to read a probable cause statement from a police officer saying, okay, this is why we believe that she committed the crime. It's not going to be but maybe 5 or 6 paragraphs long. All she's got to do to prepare for it is read through those 5 or 6 paragraphs and then have arguments against it. Say, okay, why do we think that she's not a flight risk to the community? Well, she's a 2nd grade teacher. She's been employed as a 2nd grade teacher for X amount of years. She has stable employment. She hired an attorney. She has family support. There are all kinds of reasons that you can come up with to say, this is why she deserves bail and not to be incarcerated during that time. So bail hearing, probably not a lot to freak out about. Maybe the fact that she's been gone for a long time. She might be a little nervous, but honestly, not that big.
Be seated. Okay, let's hear it.
Your Honor,
just to refresh your memory, the accused was deemed a flight risk due to an earlier custody hearing when she threatened to run off with her daughter.
And yet,
So I will say, that's pretty real so far. As a brand new attorney, I didn't know when the judge asked to just, okay, he would ask a basic question and he wouldn't address it to anybody. I wouldn't know who he was talking to. I hadn't seen one of these hearings happen before, so I didn't know the exact order of them. The guy that trained me on criminal law did show me around the court, and that was about it. So didn't get a ton of training when I first got thrown into it, which actually is, I'm told, the way that a lot of firms work. Anyway, so to stand up and start answering a question that you don't know who the judge was addressing, yeah, probably pretty real.
your husband and I never quite saw eye to eye, ma'am.
Your Honor.
Mrs. Florrick, don't talk. But if the prosecution thinks that this will in some way prejudice me against your client, he is sorely mistaken. Nice try, Matan. So, Ms. Lewis is granted pretrial release with electronic monitoring. She is restricted to temporary housing, attorney's offices, and transit in between. And given that this is a rerun, I'll set the trial date for the 25th. Now, are we all happy? Good.
Okay, I don't believe I've ever seen a murderer get out with zero bail. That wasn't a straight own recognizance release, which the other attorney insinuated she would probably get. I don't think there's any chance that she would get her own recognizance release. It was electronic monitoring. In Arizona, we would call that pretrial services, which is a little bit like being on probation while you're awaiting trial. But electronic monitoring and no bail, I don't think so. What I was expecting to hear was something along the lines of maybe somewhere between $50,000 and $100,000 secured appearance bond, meaning she would have to pay 10% in cash and then the rest in collateral, and released to pretrial services with electronic monitoring or something along those lines. But just straightforward electronic monitoring, wow, that is soft. Okay, so great question from Alex, the producer. What is your own recognizance? Your own recognizance is just you promise to show up. That's it. They're saying, we're releasing you. We're not requiring a bond. We're not requiring you to pay any money or anything like that. You're just released and you're promising to come back, and we expect to see you at your next court date. Next level is pretrial services. You have some level of supervision while you're outside, which might mean they're just calling you and saying, hey, just checking in. Yep, you're doing well. Okay, great. Sort of next level of that, pretrial services with electronic monitoring, which is what she just got. Electronic monitoring being probably like an ankle bracelet, GPS style. So another good question, is it normal for her to not get a chance to speak at all the way that the judge was acting toward her? No, I don't think that's very practical. Typically speaking, the way that these go, they ask the prosecutor, okay, how do you see this? Okay, defense, okay, how do you see this? And then the judge would get some of his own thoughts. He got straight to his own thoughts really fast. His own thoughts were that it was a mistrial and at least 6 jurors were convinced she's not guilty. That leans strongly in favor of her being out on bond. Remember, she was incarcerated at this point. She was being held in jail at this point. So getting her out on bond would be a victory. But out on no bond with electronic monitoring, no, that's probably not going to happen. The other thing that I found really impractical is for the judge to say, oh, I recognize you as being the wife of the state's attorney for Cook County is what they called it. I don't think he would even mention it. Even if he did recognize her as that, even if he had a problem with her or had absolutely no problem with her, he wouldn't begin a hearing by saying, oh, I recognize who you are. And but don't worry, that won't have any influence on my decision. He's probably just going to keep his feelings to himself. I would say even a couple of judges that I have had a good working relationship with, a few, months into being in their courtroom nearly every day, have gone off the record and just said, oh, hey, we haven't seen you for a little while, Mr. West. It's good to see you. And that's it. That's all I've gotten from that. To have a reaction like that on the record, probably not.
Do you need to take a break?
No. Just if there was some water.
Sure. Sonia, we need some water in here.
It's going to be about 5 minutes, but then I've got to do his depo upstairs.
Okay. Tell me when you're done.
You say this man ran to a red pickup truck here and took off in this direction across the parking lot. There's a surveillance camera here, and the prosecution played it to make you look like a liar.
I'm not lying.
But there's no truck on the tape. And that's why you're facing a retrial now and not an acquittal.
I think what Clinda is trying to say, Jennifer.
Okay, so you're probably familiar with the term acquittal. Just simply means not guilty. The jury finds them not guilty. So in this case, they're saying, hey, you convinced 6 jurors you weren't guilty, but the other 6 weren't convinced. So you had a hung jury. So we need to move the ball in our favor to get it to, not guilty.
The judge polled the jury and they deadlocked 6-6.
Yes, well, the judge would only declare us deadlocked if we were evenly split. So some of us agreed to change our vote to not guilty just to get out of there. If it hadn't been for juror number 9, we would have convicted. She didn't convince us. She exhausted us.
All right, if you're wondering how she's talking to jurors at this point, this actually depends on the jurisdiction and what their rules are for how quickly you can talk to a jury. But after the jury has been discharged, or in other words, they're released, they're done, there's a waiting period. That's the part that depends on the jurisdiction. And after that waiting period is over, you can actually contact them and ask them questions. How easily she found this information, I'm not entirely sure. I'll tell you, I've never been in a situation where I had to contact my jury after the fact. So not sure how easy that information would be to come up with. I would say pretty difficult, but if you have a good investigator, they'd probably be able to figure it out.
That lady, I liked her. The defendant, Jennifer.
No, that lawyer lady. She never put on airs. I like that.
Just so I'm clear, the defense expert argued that the gunshot residue on Jennifer's hands came from the struggle.
Sweet.
Is that why you held out?
Oh, I don't know about that. I just tend to get a feel. Don't I, Cyrus?
Okay, so if she's paying attention, if you're paying attention at this point, you're supposed to be freaked out because you're going, oh, great. They had a no reason for the holdout and everybody else was ready to convict. So yikes. Yeah. And her one reason for holding out was the fact that she liked the attorney. Great. We have absolutely nothing to go on.
Visiting hours are almost over.
Attorneys don't always have visiting hours in jails. In fact, a lot of our local jails here in Maricopa County actually make attorney visitations available 24 hours a day. I've gone and visited clients at, let me think, 2 a.m. because they actually had court an hour later. So yeah, we do actually have night court here sometimes. They have to be seen within 24 hours. So if they're arrested and 24 hours later happens to be 3 a.m., they'll make sure to get them seen before 3 a.m. But anyway, yeah, the jails don't always have visiting hours, but yeah, maybe it changes a little throughout the country.
They said a visitor. I thought Mom.
I've been busy.
It's good.
But that wouldn't apply to her in this situation. I see. She's not visiting as an attorney. She's visiting as a good wife. Get it?
We'll use most of it for your court costs. The rent will come out of my salary, and the kids are going to have to stay in public school.
How are they?
I was looking closer. I expected a little mistake that they make in jail situations all the time when they're presenting papers. They usually have a paper clip or a staple on them. Actually been good here. Those aren't paper clipped, they're stapled. You can't hand a paper clip or a staple to an in custody. They'll pull it out, they'll pocket it, they'll try to use it to break out of their handcuffs, all kinds of stuff like that. But no, they didn't do that. They did well.
As soon as the cops found gunshot residue on Jennifer's hands, they had their suspect. So what if they pitted everything else?
And what if they didn't? Arguments are cheap. What's that?
Page 1.
It's a bad fact, but every fact depends on how it's presented. They found gunshot residue on her hands, so she was shooting, right? But a person that's shooting can actually have gunshot residue all over them, or a person that's in the general vicinity of a shot could also have some gunshot residue. So my question at that point would be how much gunshot residue was on her hands, which would be theoretically closest to the gun if she was shooting, and was a kind of an equal amount to what was on her face, her legs, her toes, whatever, and try to say, well, this is an amount of gunshot residue that would typically be, somebody that was close to a round being fired, but not somebody shooting. So, and maybe that's not the case here. We'll see. But just because you hear a fact like that, gunshot residue found on her hands, when you hear things like that on the news, may not necessarily be what you think it is.
See, the computer automatically records the surveillance, marks it with date and time.
Is that the night of the murder?
Yeah. I mean, even if the computer did mismark it, I make an hourly tour of the lot and I didn't see no pickup truck. Look, that's me. 11:03.
Typical surveillance videos are usually kept on a pretty tight loop. Most of the ones that I've bumped into in my time are erased after a maximum of 10 days. And in fact, when I say most of them that are private companies, usually it's like 24 to 48 hours. You've got to tell them, please preserve that video. So for it to still be on there, and maybe the cops did, and maybe that's why they still have it. Don't know. But just a fun fact, if you actually were to call an attorney and say, oh, do you know what? I bet there was video of the car accident that I was in a month ago, or even 2 weeks ago, might be gone by then. If you think there's video that you need to get, you need to tell those people right then, hey, does your camera point toward that street? Because this guy just hit me and you tried to blame it on me. Yeah, they need to know right away.
And how would you describe your husband's relationship with his first wife?
Well, most of the time it was fine, friendly even, but after the last custody hearing, Michael was pretty worried about Jennifer.
Objection, Your Honor.
On what grounds?
Hearsay?
Nice try, Mrs. Florrick. I'll allow. Go ahead, Mrs. Lewis.
He
wasn't really that nice of a try. She was saying he was really worried about something. She wasn't talking about an out-of-court statement. And in fact, hearsay can sometimes sort of weasel its way in if you don't make it a statement. If you don't say, what did he say to you? Then you're not asking for a question that the response is hearsay. But if you say, did you guys have a conversation? Yes, we had a conversation. What was that conversation about? And as long as they're not repeating words, say, yeah, I remember that we had a conversation about how angry he was with his ex-wife. You can probably get that in, and it's not hearsay because it's not a statement. It's a memory of a conversation.
In your testimony, Mrs. Lewis, you claim that Jennifer wanted sole custody, but isn't it true?
Objection.
Sustained. Keep trying, Mrs. Florrick. You'll hit on it.
In your testimony, you testified that she wanted sole custody. Isn't that true? Yes. Then move on. That's what they're trying to get to.
Whose idea was it to have dinner? Jennifer's or Michael's?
Michael's.
So wouldn't that suggest that his attitude had changed towards
Objection.
Jennifer?
Sustained.
Thank you.
Okay, so they're trying to show that she's out of practice for a courtroom, which she would be after 13 years. You would think they would probably do some kind of mock trial or something, maybe some kind of just witness prep. I'm going to ask questions like this, get her back into the swing of things before she's actually in trial after, I don't know, they insinuated maybe it was like a week or two, something like that. I would guess that this law firm would want to do that. I would guess that she would want to do that. I'm not sure why they didn't, but to show that she is out of practice after that long, sure.
But in the case of the Honda, the victim pulled over because he had a flat.
Yes, ma'am. There was a nail driven into the front driver tire.
I see. Now, why is this something a carjacker would never do, Detective?
It would defeat the purpose. I mean, how do you steal a car with a flat?
Not entirely sure she'd get away with this. Sometimes maybe a lot of these tend to be pretty leading. Maybe might be able to just simply say, instead of why would that be something a carjacker would never do, which he hasn't testified to yet, would a carjacker ever do that? No. Why? Then you actually have a foundation for it. You're not leading them to a particular question. So maybe not exactly like this, but, you know, in the interest of moving things along in a drama, yep, it's doing well.
Detective Briggs, what is the pit?
Excuse me?
In police circles, what is the pit?
Objection, Your Honor.
On what grounds?
On the grounds that relevance.
Well, let us see how relevant this becomes, shall we? Detective?
That's, I mean, a good objection. I probably would have made it too, especially since she didn't try to lay a foundation for it first. Detective, are you familiar with the police term called the pit? And can you tell us what that term is? I mean, he didn't even say that he has knowledge of it. So, or is there such a term called as the pit? Anyway, so pretty solid objection, but at the same time, I would probably do in the judge's place, I'd probably do exactly what he did and say, yeah, I don't know if it's relevant yet. Let's find out.
Did you bury something?
We all know what's going on here. Peter Florrick was a corrupt and convicted state's attorney. If evidence was buried, he buried it. And now she's benefiting from his knowledge.
Which still leaves you with some pages missing here. I'll give you...
If she actually had any knowledge of it, she wouldn't be able to work this case. She'd have a conflict. So if she did actually hear something from her husband, she probably shouldn't be working the case at all. But I don't think they've even insinuated that that happened. So just because her husband was a how do you call him, district state's attorney for Cook County, doesn't mean she can't work this case. Talked a lot about that in the Lincoln Lawyer videos and things like that. But anyway, still legit here. Also, his objection to say, oh, she's trying to deceive the jury. Look, the officer could have just simply answered, no. Nothing was pitted. So we didn't even get to the answer yet. So I don't think this objection deserves this much attention yet. If I'm the judge, I'd probably say, no, I want to hear the answer first. And if he just said, no, nothing got pitted. Okay, move along.
It's not just teaching an old dog new tricks, it's teaching an entitled dog new tricks.
Oh, come on, Diane. The problem is she's catching evidence that you overlooked.
This guy should be found guilty of wearing an all-striped suit. Striped jacket, striped shirt, striped tie. Just shouldn't happen. Fashion felony.
Yes, that's correct.
And you saw no pickup truck, no carjacker racing past, nothing the defendant claims she saw.
That's correct.
Thank you. Nothing further, Your Honor.
Mrs. Florrick.
Could we have the monitors in, please?
Okay, now you're going to ask him, was anything changed? Was anything altered? He's going to say no, and then you're going to introduce the copy of the video that you were just looking at as impeachment evidence. The prosecution's going to object, saying we've never seen it before, but it's for impeachment, so it's going to go through anyway. Official prediction for the scene. Let's see.
Here are 3 images. The middle is the image of the surveillance from the 15th, the night of the murder. And the one over there on the left is image from the 14th, the night before the murder. And the one on the right is from the 16th, the night after the murder. Can you see the dates on those?
Yes, I can.
So, as you said before, there you are, the night of the murder at 11:03, making your circuit of the lot. And there you are, the night before the murder, and the night after, doing the same thing. It must get old.
No, ma'am. My job doesn't pay as much as yours, but I still love it.
Okay, good. Now, Mr. North, let's fast forward, shall we? 45 minutes, the night of the murder, and there. What do you see?
Nothing.
No? It's right there. Maybe you need to move in a little closer?
Oh, it's a shopping bag. It looks like a shopping bag.
Actually, it is. It's a plastic shopping bag. It was a very windy night that night, and it blew across the lot at 11:40.
Your Honor, objection. What does this have to do with anything?
Beats me, but I'm interested, aren't you, Mr.
Now, that was a pathetic objection there. The most common objection that you see on TV dramas is relevance, but it's almost pointless. Relevance is going to catch almost nothing. We make the objection almost never. The objection here might have been, if you are a prosecutor, might have been they're building momentum towards something and I don't know what it is, but I don't like it. So I'm going to try to cut this momentum up a little bit. But the judge is making the right call here. He's going to overrule this and let her keep going.
Let's fast forward the other two monitors, the night before the murder and the night after the murder, to the same time code. Here's the 14th and the 16th. What do you see?
I don't know.
I think you do know, sir. Either you have a plastic bag that blows across your lot every night at 11:48, or these are duplicates of the same tape.
Objection, testifying. She can't say that. She can say, oh, you can't see the plastic bag? Oh, in the exact same spot on all three videos? Is it commonplace for a plastic bag to blow across your parking lot at the exact same time 3 nights in a row? Right down to the second? So she can say that. She can't say, oh, well, here's what's happening, because that's testifying. Now, what is a little surprising here is that we haven't had an objection for these other two videos. I don't know how they could have worked their way into evidence before, but maybe there is no objection because he understands that it's impeachment. But actually, it couldn't even be impeachment because he hasn't on screen testified to these videos are not altered in any way, or I didn't change anything in the videos. I know them to be a real representation of what actually happened that night. We didn't see that on screen, but it would be in the very boring part at the very beginning of your questioning, laying the foundation for the video. So it may not be in the segment of the questioning that we saw. We could just imagine that it happened.
No, it's not what it looks like.
I understand, sir. You didn't willfully mislead the police.
Yeah, that's correct.
No, it's just that it gets cold out there and sometimes you don't make the circuit of the lot.
Yes.
So on the nights that you don't go out, you don't record the actual surveillance image. You set your computer up to duplicate the night before, just in case your manager checks it. Is that correct?
Yes.
Just so I'm clear, there is no recording the night of the murder. And you were never there to see or not see the pickup truck or the carjacker.
I'm sorry. Yes.
Great line of questioning, aside from the fact that she didn't actually ask questions. It could have been done exactly that way if it had just been finished with, is that correct? Or, right? The testifying part wouldn't have gotten in, but our line of questioning here about, so you just alter the video so that when you don't actually do your check, it appears that you do. Is that right? Just finish with an exact, is that right? And this would have been totally realistic.
Mrs. Florrick, I just want to say congratulations. I heard you did well in court.
I just wanted to say Britta is the worst. We got to watch Community and get reference.
If the deceased were to divorce you, you would be cut off from his premarital savings. Is that correct?
Objection. Relevance.
Sustained. Move it along, Mrs. Florrick.
Sorry, wait, if she's trying to point the finger in another direction, that definitely could be relevant. So to object to that on relevance and to have it sustained, probably not.
Mrs. Lewis, isn't it a fact that a year ago at the time of the murder, your brother worked at a dog track?
Objection.
Sustained.
No further questions.
She might figure it's enough just to get it in the jury's mind that she's connected him now with, okay, there was dog hair, he worked at a dog track, yeah, maybe it was from him. She might feel like that's enough to get it in the jury's mind and she didn't care about the objections.
So our state's attorney, in his radiant wisdom, has decided to withdraw the charges against your client and pursue a case against Mrs. Lewis's brother. Isn't that right, Mr. Brody? All I need is a yes or no.
Yes.
Good. Then we're done here.
Thank you. Thank you so much.
Probably every bit of that would be with paperwork and email exchange, but it's a lot more fun watching it in the judge's chambers, right?
I still can't believe it. The lawyers think we have a really good shot at overturning this, and they're going to make an official statement tomorrow. But I just wanted to tell you first. I'll see you soon. I love you.
Fun ending for the episode. We wrap up the story that was actually happening in the episode and went ahead and gave us an update on the underlying drama, right? So I got to tell you, I've been asked, a bunch of people have been asking me, how do you rate this? Where do you think it stands on? So I've just decided I'm going to start grading every episode. We're going to have 3 factors. The first one is going to be realism. The second one is going to be the performance of the attorneys that were in the episode. How well did they actually come across as lawyers? And the last one is just going to be the Hollywood effect. How fun was it to watch? How dramatic was it? So this one, the realism, actually a lot better than I thought it was going to be. Not great. I'm not going to lie. There were some things that just, wouldn't happen that way. But yeah, like B-. The attorneys, I think both of your main attorneys, both prosecutor and defense, both came across really well in their part, especially this good wife character here. She is coming across as somebody that really knows the law, but hasn't been practicing for a long time, which is exactly what her character is. And then the last one, the drama. Yeah, this is a fun show. I'm going to say I'm probably getting pretty hooked and excited to see what else this series has to offer. So let us know what you thought in the comments. If you want us to keep going on The Good Wife, tell us that. If you thought it was just the worst show ever, I'm surprised, but tell us that too. We'll see you next time.